I'd like to welcome everybody to this meeting of the Board of Adjustment. It is 6:01, so we'd like to get this started. First thing on the agenda is the roll call. So what I'm going to do is just have everybody start down from my left side so you can know who they are. Yvonne, just to let you know, was an alternate. She is now a regular member on the board.
Frank McElroy.
I'm Earl Hartzog.
And Richard Jevitt. So the next item on here is the hearing of residents. We do have someone signed up, but what I would like to tell you, I mean, I don't mind, we can call people up to speak, but if this is in reference to a particular item on the agenda, if you would prefer, you can address it at the time that we do that particular agenda item. Again, the choice is yours, whichever way you want to go. So I believe the first person we have on here is that Pia Caruso? Would you like to speak now or just wait on? Okay. Thank you. And Margie Crenshaw? All right, thank you very much. Okay. The next thing that we're going to do is have a presentation on the Board of Adjustment laws, rules, and regulations. And we'll ask Attorney Mr. Santee to kind of give us a bit of a breakdown on it. Mr. Santee?
Good evening. Megan has told me I only have 2 hours for this, so I will try to condense it down. I also thought y'all would appreciate palm trees, given it's going to be about 25 degrees later this week. So first and foremost, the Board of Adjustment is unique and among boards in all cities where they've appointed a Board of Adjustment, in the sense that you're a quasi-judicial board. And so a lot of what we're going to cover tonight is just, it's going to be a reminder for some of you. It's going to be new for some of you with regards to your roles and the responsibilities that you have in fulfilling your duties. You might enjoy knowing, in my opinion at least, the second most powerful board that any city appoints, because any appeal from the Board of Adjustment has to go to a district court. P&Z think they are, so don't tell them. I mean, they think they are, but they're just a recommending body. Their stuff has to go to city council. They just make recommendations. So this is the difference. So the zoning commission, they're advisory in nature. They perform advisory functions. They also help develop the comprehensive plan. They review reports on amendments. Their focus is usually on a larger scale than what the Board of Adjustment focus is. And zoning is always a discretionary act. So for a zoning Board of Adjustment, as I said, you're quasi-judicial, and you deal with issues on a tract-by-tract basis. So when something comes to the Board of Adjustment, they are needing action. You're an action agency. You're the only relief valve for whatever it is that's come before you that they seek. And, you know, as such, you are the final authority with regards to whatever that rule of law is, that question that is before you. You say up or down, and from here it goes on to a district court. So cities don't have to create boards of adjustment, and in a general law city, for example, as Yvonne knows, the city council considers the Board of Adjustment. They don't have to have a separate, but in a home rule municipality, they do have to be separate. You have to have at least 5 members. You serve 2-year terms. The city council can determine what that appointment procedure will be, as they've done so here. But removal of a sitting member of a Board of Adjustment can only be for cause on a written charge after a public hearing. That's in the statute. We'll talk a little bit later about some of the provisions in your rules of procedure. There's a little bit different information in there, but the statute says that a sitting member can only be removed for a cause on a written charge after a public hearing. Alternate members may be appointed, and importantly, each case must be heard by at least 75% of the membership, which is why most boards of adjustment always have alternates who are appointed, because we need a full board to hear most cases, because it's going to require, like cases tonight with 4 of you here, we need an affirmative vote from all 4 for that case to be approved. It also allows for you to adopt rules, which you've done. We're going to talk about those at the end tonight. Presiding officer you can administer oaths. That's one thing that we'll look for in your rules of procedure as to whether or not you ever do that. I have some boards of adjustment who place anybody who's going to stand here and offer testimony on a board of adjustment case, they swear them in. And the reason for that is, remember, from here it goes to a district court. And so you actually, being quasi-judicial, have that authority as well. You place people under oath, you can actually subpoena information if you need it in order to make a decision. I guess in the time I've been doing this, I've had about a half a dozen Board of Adjustment cases that went to district court where the Board of Adjustment was sued. And how that works is that court issues a mandamus down to the city, and we have to have the minutes, right? And so in those situations, action minutes don't serve us well. And so one of the things that we always look for is more comprehensive minutes on our Board of Adjustment meetings on the items where things are considered, because that's our record that we're going to rely upon at the district court. That's why sometimes boards elect to place people under oath. It's also why when you make decisions here, there can't be too much discussion by a Board of Adjustment as to what the decision is being made and what the reasoning is for the decision and what the findings are that this board is making in order to justify whatever decision it arrives at, because that's our record if we have to go to district court and defend it. All meetings are open to the public. This is just more information on your meetings. This is taken right from the local government code. It talks about the minutes and records be filed immediately in the board's office in our public records. So she'll be up all night doing the minutes tonight, I'm assuming. Not quite, but it is important, because the reason for that, and the reason why it talks about immediately, is if I don't like the decision, I have 10 days to file my appeal. So it is rather quick. And so when those appeals are filed, cities are often scrambling to make sure they get that complete record up to the court for that review. So what are the authorities that you have? You can decide appeals from a decision of an administrative official regarding the zoning ordinance. In that instance, you may reverse, affirm, or modify an administrative official's order, requirement, or decision. All of these things are in the local government code, so this is taken straight from it. It's really one page, actually half of a page is all it amounts to, but there's a lot of information packed in there. The case law generated by that half a page, there's volumes of case law generated by that half a page where it talks about the Board of Adjustment. So where this happens and where you'll see this come into play is it's usually Brian's fault. So if Brian will make an administrative decision, I know it's hard to believe anybody ever disagrees with him, but if they do, they have a right to appeal his interpretation of that zoning ordinance to the Board of Adjustment. Have you ever had one appealed here? Was it you? That had to be someone else, yeah. So it doesn't happen very often. I agree, that's been my experience as well. It is not the most common thing. More common is the seeking of a variance. And you can authorize a variance, and your local ordinance that we'll get to goes almost verbatim from this. Public interest is served, substantial justice is achieved, and an unnecessary hardship would otherwise result. And the reason why unnecessary hardship is bolded and underlined is because that is the most, in Board of Adjustment world, that's the most litigated thing that there could possibly be, is what constitutes a hardship. And what we've learned over decades of case law isn't necessarily what a hardship is, but more or less what it isn't. Because that's when those appeals happen, right? I say I have a hardship, a board says, no, you don't. They deny it, so I sue, and it goes up. And the court's either going to agree or disagree. But what the court isn't going to do is substitute your judgment with its own, right? So unless this board is arbitrary and capricious in your findings as to why you believe and what you believe with regard to a hardship, a court is not going to substitute its judgment for your own. It's going to say, was there reasonable evidence that supports the findings of fact made by that Board of Adjustment? If so, it's a very high bar, let's put it that way. It's an abuse of discretion standard. It's the highest bar that you can have to get over to overturn a decision of a board, of a quasi-judicial board. You can also hear and decide special exceptions to the terms of a zoning ordinance when the ordinance requires the board to do so. This is an element that I don't believe, Schertz, I noticed in your ordinance, I don't believe you've really gone into and developed what would constitute special exceptions. You do have the ability to get a variance. A special exception, to give you an example, is more limited and it's defined. So if there's a particular, I had another client here in the San Antonio area where, one of the things about zoning ordinances and zoning classifications is we have this idea that all properties are created equal within the same classification, and so you all play by the same rules. This particular city had development that was residential in nature that backed up on the one major roadway that ran through the city. And so they wanted to allow things in the backyards of those residential area that perhaps they didn't want or they didn't feel was appropriate in the rest of the community. But like, how can we do that? Because it's got the same zoning. So we came up with special exceptions that because they backed up on Northwest Military Highway, they could allow things within the setback to that rear that they wouldn't allow in any other residential community because the circumstances were such that it was not couldn't be harmful to anything behind them because it was Northwest Military Highway, and all the neighbors were likely situated, right? So they were all situated along there, and it had to be that you backed up to it. So what they did was they created a situation where you could come to the Board of Adjustment and seek a special exception if you met specific criteria, and only these criteria. And so that's where that comes into play. The reason why it would still come to the Board of Adjustment is because you didn't want to just make it carte blanche where it was by right. It had to be through special exception so that Board of Adjustment got to hear what criteria, what the facts were, why they wanted to do it. They could put any additional conditions on it and safeguards that they wanted to. If you don't have it here, in my opinion, it's a helpful tool. And it just could be that those circumstances have not yet arisen in Schertz that fit into an area where your staff believes, well, this would be a good tool for us to have. So what can you not do? You cannot grant a use variance, grant an increase to the variance requested, or overturn a staff decision and authorize a variance from the zoning ordinance or approve a request with less than 75% affirmative votes of the members. Now, I want to go through these a little bit more detailed. Can anyone tell me what a use variance is? I'm sorry if they didn't warn you this was interactive, because it's always going to be. Yeah, so the idea of a use variance, so what happens often, and I've seen folks try this, is they want a variance. They say they want a variance. What they really want is they want to do something on the property that the zoning doesn't allow. It doesn't allow you to do certain activities, like you're saying. We can't grant a variance to allow something there that is not allowed there. You need different zoning. If that zoning category doesn't fit, you need to go through the process, and if they wouldn't change your zoning, you don't get to come to the Board of Adjustment and say, well, let me do this anyway. And those do come up, and sometimes it's not as clear. It sounds like it's real clear that that would constitute a use variance, and sometimes it's not. Signage can get into that area sometimes, depending on the type of signage and whether or not it's viewed as a use or structure. I tend to view signage as a structure, typically if it's freestanding. So, but I've had that come up before. You can't grant an increase, so it's very important. And I've had many cases that when the applicant gets before the board and they've posted it for a specific variance, let's say a 10-foot variance from the 15-foot setback requirement or something. And they get here and they say, well, my builder says I really need more than that. And it's like, no, that's too bad, because we can't grant you more than what has been posted and sent out in notices, and we can't go beyond what is in the application. If you need more, you need to start over, and we have to begin the process anew. And one of the reasons, and that's really just a due process thing, right? It's the same reason why if you come before the zoning commission and you want a particular intensity of zoning classification, you can't go more intense. You can't, if you applied to have neighborhood commercial, you can't come in and then just have general commercial. That's a more intense use. That's not what was noticed, that's not what was published. This is along those same lines. We can't grant more than what was requested and advertised. And again, as I said earlier, we got to have 4 or 5 affirmative votes for anything to be approved. So what can you do? You can, in addition to what we already covered with the administrative decisions, you can grant a variance that will not be contrary to the public interest, where due to special conditions, literal enforcement would result in unnecessary hardship, so that the spirit of the ordinance is observed and substantial justice is done. And like we said also, you are the escape valve when land does not fit the ordinance mold. The tough part on any of this is these are like, these are lawyer words, and y'all have to take the facts and fit them into a decision that works. And, like I said, unnecessary hardship is one of the most litigated things that happens within the Board of Adjustment world. And here's why. So what they are not. So these are not unnecessary hardships. Now, these are not what I've made up. This is basically years of case law put into a few bullet points here, in a sense. Property that cannot be used for its highest and best use, financial or economic hardship, self-created hardship, the development objectives of the property owner are or will be frustrated. Now, we're going to spend some time in a few minutes on this financial or economic hardship, because the legislature made some changes this last session that you've not yet adopted and you don't have to adopt, but we're going to cover them anyway, because I think your staff intends to bring that amendment to the P&Z to see if they want to add that. It would give a little bit more flexibility with regards to a financial hardship, because historically, financial hardships were not considered an unnecessary hardship. Financials had nothing to do with it, and they weren't part of the consideration. So the legislature is giving you the opportunity to soften that a little bit, and we'll cover that. The idea that if I'm not granted this variance, I won't be able to develop property the way I want to. If I come in here and say, I need setback variances to all these lots, but so I can fit more in here, no. That's or I need to make this square footage of this building bigger because I can lease it for X amount per square foot. I mean, again, that's me thinking the highest and best use is something and me wanting to maximize my investment. Those don't constitute hardships. I had one where there was a couple had purchased a pie-shaped lot in a subdivision. It wasn't built on, it's a vacant lot. There were dozens of vacant lots in that subdivision, but they wanted this one, and they wanted to build a house on it that was too big for the pie-shaped lot, would have fit on other lots. They asked for a variance to the setback requirements in that zoning district so they could build this house. And that Board of Adjustment was like, you got some options here, a smaller house, a bigger lot. And you should really exercise one of those options if you have that ability. So had one too where a family wanted to, this was in West Texas. So if you know West Texas, you know there's a lot of mesquite trees, there's some cedar trees, and there's few other trees in most of West Texas. There was an oak tree on this particular lot, and that's all they had to say. They came in, they wanted to expand part of their house, and they could do it on one side where there was this tree, and they wouldn't have to have a variance, or they could do it on the other side. They They'd need a variance, though, but there wasn't an oak tree over there, and the Board of Adjustment granted it with no problem. They said, well, you didn't create that hardship. That's a hardship because we don't have enough, 100-year-old shade trees in that neighborhood. We don't want you cutting that tree down because there was no tree preservation ordinance that would have prevented it. And so hardship can sometimes be in the eye of the beholder, too. What is unnecessary, and they did not want that oak tree coming down. So this is taken directly from your UDC. I'm not going to read through all of it, but if you want to see what your authority what it specifically states, if you haven't looked at it, it's important that you do so, at least be familiar with it. But this talks about what you can do, and it's taken almost verbatim from the statute. It goes on the variances shall not be granted to relieve a self-created or personal hardship, nor shall it be based solely on economic gain or loss, nor shall it permit any person a privilege in developing a parcel of land not permitted by this UDC to other parcels of land in the district. And in order to make a finding of hardship, there's some things that you have to be able to determine. So when I talk about findings, if I'm coming before you for a variance, my burden, it's not yours and it's not the staff's, it's my burden as the applicant to be able to show that by granting this variance, you're going to meet these objectives. I should have evidence that shows that the requested variance does not violate the intent of the UDC or its amendments, that special conditions of restricted area, topography, or physical features exist that are peculiar to my property and are not applicable to other parcels of land in the same zoning district. There's something about my parcel that prevents me, maybe there's a natural drainage area, or there's a low area, or there's something that I really can't build on because it will affect somebody downstream or something, so I need to push my development over, and I've made it as small as I can make it and it still be usable, and otherwise this whole property can't develop. Well, that might be something, right? I mean, there's topography, we want to be able to develop that property, have it on the tax rolls, but, I've got this limited area. The hardship is in no way the result of the applicant's own actions or the interpretation of the provisions in this UDC or any amendments thereto would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district that comply with the same provisions. So those are the things that we're looking for when people come and present cases. Because you don't have to find all of these, but there has to be enough evidence that a variance is justified under at least one of these. So this is what I was alluding to. House Bill 1475 was approved by the Texas legislature expanding the variance hardship criteria. It includes additional criteria for finding a necessary hardship as applied to structure. So this is existing structures if someone comes before you. So in exercising its authority under subsection A3, the board may consider the following as grounds to determine whether compliance with the ordinance as applied to a structure that is subject to the appeal would result in unnecessary hardship. And what those things are these bullets right here. The financial cost of compliance is greater than 50% of the appraised value of the structure. Compliance would result in a loss to the lot on which the structure is located of at least 25% of the area on which development may occur. Compliance would result in the structure not being in compliance with the requirement of an ordinance, building code, or other requirement. Compliance would result in the unreasonable encroachment on an adjacent property or easement, or the municipality considers the structure to be a non-conforming structure. So these are not yet in your UDC, so these are not, for you to apply this evening on any cases coming before you. If this is added to your UDC, though, then, staff will update you as to that being done. And then when a hardship, this will also become part of the staff report. If there's a structure that meets the criteria and someone's asking for a variance, and the staff believes that any of these conditions are met, that will become part of the staff report so that you're free to do that. In the past, you were limited on what you could consider financial hardship as an unnecessary hardship. So I want to talk briefly, I'm not going to take up a lot of your time on rules of procedure. You have copies with you, and I encourage you to take these with you and do a good review of them. If you've been on the board a while, it's probably a good time to do a review and maybe update them. This is just we do the training for ACOG, so we do training for Board of Adjustments in this whole region, and so this is just a slide that we use just to kind of advise them as to what are the common elements of rules of procedure, or order and procedure. In fact, our ACOG training is in April, so it's broader than just Board of Adjustment, it's all zoning stuff, but it's free and it's streamed, so I mean, you guys will be able to watch it as well if you want to. So in doing that, I think I would encourage you at a future meeting to, go through this, mark this up. If you're a new member, it's important to have your input. If you're a member who's been on here a while, this is an opportunity to go through and clean up your rules. I would say get some red lines, look at it, ask questions on it, and let's get those to Megan, who can then get them to me, and we can assist with just doing a general update to these. When I looked through them, like I said, I don't want to keep y'all on this item and go through these tonight, but I saw lots of opportunities to make some improvement and maybe condense some of these things, and there also appear to be some provisions in the rules of procedure that are actually go beyond what statute would provide as far as removal and things such as that. So it's just something I think to look at and take an opportunity to perhaps update. The meat of them are fine with regard to what your authority is and what your power is, and so that's why we're not going to spend time on it. So here's some practical tips that we always offer. Be cautious, don't speed up the process. I mean, I understand time is valuable. These are critical decisions, though. The board does not meet that often. Things don't come up that need to come before you. When they do, they're critical matters, particularly for the applicants, right? You're their last opportunity for relief from the zoning provisions other than going to court, and that's an extremely high bar, as I already said. Goes without saying, treat all applicants fairly, make proper findings. That's the big one. Now, staff, this is for staff too. I expect staff on boards of adjustment, where I sit as legal counsel, when those staff reports come forward, they are the subject matter experts, and they are providing you their expert opinion through that staff report. And so if they have an opinion, if they believe that criteria is met or not met, it should be reflected in the staff report. It is. I've already checked with Megan to make sure that there's a recommendation in there. Because if you make a motion to approve or deny, you should be able to, and I'm not suggesting you do this, but you should, if the staff report is done properly, you should be able to say, I want to make a motion to approve, for example, for the reasons outlined and stated within the staff report that this application meets the criteria needed for a variance, something along those lines. Because that allows me to take that staff report as evidence and include it in the minutes, and it goes up to the district court if there's an appeal. And so, when I do training on the other side of this, when I'm training planning staffs and giving talks on that, that's what we focus on. We focus on crafting a staff report that your board can rely on and your board can accept. And, because that's what the board expects. The board comes up here and they are relying upon their attorney to keep them legal, and they're relying on professional staff to make them aware of their professional opinion and things within the UDC that maybe you haven't digested because, you have other things that you do before you come and sit as a Board of Adjustment. Frame comments in objective terms, and of course, be attentive. One of the things I also like to encourage all boards and commissions and councils is that, public hearings, and I've sat through public hearings that go hours. I know you have as well, if you've been here at council meetings or P&Z. To observe, and that's democracy at work. That's people exercising their rights. It's due process, and it's important. And so however long they take is how long they take, and every single person who comes up there to speak, it's the most important thing to them at that moment in time, and so it's worthy of our attention as well. And they have important things to say, and we take those notes, and we take it into consideration when we make our decisions. And that's all anybody that stands here can expect, right, is just be fair, just listen to what I have to say. And that is all I have, and I'm happy, I went through that quickly. I'm happy to answer any questions. I mean, I know this is really a refresher for you guys, but it seemed like a good time to do a refresher. Sure.
I really appreciate that. And does anyone have any questions that they would like to ask? No.
Very
Which
good.
means that everybody's going to be working on that sheet and send it to you in book form.
Good, good, that's fine.
All right, thank you again, appreciate it. Okay. At this time, we will take a look at the consent agenda, and in this group are the minutes from the, believe it or not, July 27th of 2020, which was when the last time that this meeting was held. So has everybody had a chance to take a look at that?
Mr. Chairman, I had a chance to look at it.
Okay.
I think Frank ought to make the recommendation on it since he's one of the people that voted on this. I didn't know this is what we wound up and agree upon.
Okay.
It looks that way. Memories fade after a year and a half, though, don't they? But I will defer to those individuals, including myself, who made this particular decision back then, and I will motion that they be approved.
I'll second it.
We have a motion from Mr. McElroy and a second from Mr. Herzog. Any questions? All right, can I have a vote?
Aye.
Aye.
Aye. 4 ayes, the motion is passed. Thank you. All right. What we are going to do is the items that will be presented in the form of a public hearing. Now, what that means is that staff and those that you have signed up to speak on that particular issue will be asked to speak, and that time is approximately 3 minutes that you're allowed to kind of give some information on it. Once the public hearing portion and all the items are produced by staff and the other people that have spoken, we'll close the public hearing, and then it'll be opened up for any questions and issues that the board may have to ask of anyone. So I think that's pretty clear for everybody, and I think we will get started now with item number 6A. So first thing will be the staff will give the presentation, then we will open up for public hearing, and then we will listen to any other people that may want to speak about that item. Okay, please. Okay. Board, it's BOA 2021, and considering the act upon a request for a variance to the Unified Code, Article 11, signs and advertising in order, excuse me, my eyes are, in order to permit a second multi-tenant sign. The requirement for masonry or multi-tenant signs, and to remove the requirement that that all text or graphic element to limit it to 6 inches from outer limits located at 3701 FM 3009 in the city of Schertz in Guadalupe County, Texas. Please.
Good evening, Commission. My name is Megan Harrison. I'm one of the planners here at the City of Schertz. This is for BOA 2021-001 at 3701 FM 3009. So here is the public hearing notice map that was sent out to all the residents. Here is FM 3009, Green Valley Road, and then Savannah Drive. We did send out 45 notices, and we have received 2 that are neutral and 4 that were opposed. And so we received 3 more after the staff report was submitted or sent out on Friday. So there was a total of 4 that were opposed to the variance request. So going to go through more detail, but just kind of wanted to provide an overview for the signs. So there is a total of 6 signs that the applicant is requesting. 2 are multi-tenant, and then 4 are wall signs. So here is the first variance request. The request is for 4 wall signs. Under UDC Section 2111-9C, we only allow 3. So the 4 signs are the Kellum Schertz Medical, and then 2 K logos, and then the Methodist Healthcare sign as well. The next one is to allow 2 wall signs on the same facade. So they are requesting 2. However, under the UDC, under Article 11, we only allow 1 wall sign per wall. The next one is the applicant is requesting to have 2 multi-tenant signs on their property. However, under the UDC, we only allow 1 multi-tenant sign per lot. Also with the multi-tenant sign is comes out to 194.94 square feet, and under the UDC for multi-tenant signs, the maximum is 150 square feet. And so this is that main one right here. The next one is the text and graphic limited to 6 inches from the outer limits of the sign. So what that means is that essentially you would take 6 inches around a sign and it should be clear of all writing or graphic. However, they want to encroach on that 6 inches. So as you can see here, the like electronic sign and then some of the words here they would want to encroach on that 6 inches. Next one would be to allow reduced masonry requirements for multi-tenant signs. So they're requesting to do a rock base with a aluminum stucco finish. However, under the UDC, the requirement is to have the whole thing done with masonry. So here is the variance review criteria that was provided within the staff report, as well as what the applicant also provided on their application. So staff is making a recommendation to approve the following variance requests: to allow the additional wall signs, to allow 2 wall signs on the same facade, to allow a second multi-tenant sign, to allow increased square footage on the multi-tenant sign, to allow text and graphics, including electronics, to be within the 6 inches, and to allow reduced masonry requirements for the multi-tenant signs. The applicant is here, and so I'll let them come up to provide theirs as well.
Okay. Okay. All right. Thank you very much. Okay, at this time, we will open up for public hearing, and anyone who wishes to address on this particular issue can and will. And remember, I'd like you, when you come up here, please state your name and address, and the time limit would be approximately 3 minutes for what you can say.
Sir, if I may, the applicant is here, though. They want to provide their presentation, their justification before the public hearing.
Okay? Please.
Thank you, staff. Daryl Keller with Kellum Real Estate. I'm the developer and owner of the Kellum Schertz Medical Center. I thank y'all for allowing us to be here today. Most of these requests are in our eyes fairly simple. We have been working with Dr. Kellum, which is one of my partners, who's been a doctor here for many, many years. And we wanted to present this medical center to the community of Schertz, a partnership. In order to do this, with the complexity of the 10-acre development, it grew and got really big. So in order to do this, our specialists that are coming, the Methodist Healthcare, the cardiologist, Dr. Kellum, all these signs that we're asking are in their eyes very mandatory for people to be able to exit from 3009, being a very big thoroughfare nowadays, and to be able to see the signage and be able to exit and get in the development A B, once they get in the development, they got to be able to be directed to the buildings because this is 10 acres. There's going to be multiple buildings that specialists are going to be in. So we have asked for this variance so that we can direct the clients or patients into this facility and be able to get to their destination as quickly as they can, basically. So, I mean, that's really the gist of it, is just because we feel it's needed. Absolutely.
Thank you. All right. Again, we'll start the public hearing now. I believe, is it Ms. Crenshaw? Did you want to speak on this particular issue?
Good evening. I'm Margie Crenshaw. We live over on William Scarborough. We're directly affected by this. From my own personal standpoint, I appreciate the fact that they've built this medical center and that we have this all coming in, but quite honestly, I'm not a fan of all of this additional signage, simply because even if you look over here on Schertz Parkway, on 5,000 Schertz Parkway, where this medical center is, they don't have to have multi-boards to tell you who, what, where, and why. People seem to get in there and out every single day to see their doctors, to do whatever they do by simply reading what's on the building itself. We've been in Schertz now and been in this home for over 24 years. And I'm not trying to be a whiny baby, but it's very distressing to see what they've done to the city and with all the zoning, the way that it's gone. In my personal opinion, for whatever it's worth, I would like to see it cut back, and especially this electronic, because a lot of our houses are raised, and we're already looking into this monster building in our backyard, on top of adding the electronics flashing day and night. You know, this information is important, yes, but I don't think it has to be Broadway. Thank you very much.
All right, thank you. Is there anybody else who would like to address on this particular issue? All right, at this point, we'll close the public hearing, and we'll open up to the board. Any questions? Any questions? Mr. McElroy.
Mr. Chairman, I'd like to ask the city just a few questions. Thank you. I wanted to get right to the staff recommendation.
Sorry, my apologies.
And it's essentially, it looks like it's to approve all of the requests. Is that correct?
So essentially what the Board of Adjustment can do is that like Dan was saying, was that if you would like to, approve all of it, you could, list out.
I don't mean to cut you off. I'm asking specifically here. That the city is recommending that the variances be approved. Is that correct?
Yes, sir.
Now, I wanted to go through each one of these and ask what the thinking is, the rationale is behind recommending to the board that they be approved. Because they clearly don't fit within the UDC. And to allow the additional wall signs, to allow, I don't need to read every one there, it's up for everybody to see. That's what I want to know. Why are you recommending to us that we approve this? But I don't want to get into a soliloquy here, but these ones irritate me a little bit. I'm speaking for myself. But they don't fall within the rules as they are. My thinking is that that's up to city council to change that if they see fit. And I feel that very often we're stuck doing, I'm going to call it the dirty work, that nobody else kind of wants to mess with. And not that there might not be a legitimate reason to approve that. I'm not even getting to that point. But what is the city's rationale for recommending approval when it clearly doesn't fit within the UDC or would have been approved by the city?
Sure. So again, I think here's me kind of, if I will, this. So on the one hand, it's a philosophical approach of, we have this rule, if it doesn't meet the rule, then it doesn't meet the rule, and it should never be approved. And there becomes no relief valve for that unusual circumstance where there is a hardship. And while it's certainly reasonable to say, well, we just need to change the rules, the thing to keep in mind is those rules, again, apply to everybody, and if there's no relief valve for a hardship, then there's no relief valve for hardship, and that's a philosophical way to approach it. But I think to your question as to why staff is supportive of these, part of what we looked at is if they had chosen to adjust certain elements of their development, would these have potentially met and then been allowed? And so, for instance, when you're only allowed the one multi-tenant sign, if they had come in and subdivided the property and created separate parcels, now we've got two separate parcels, they can do two separate signs. And I think that's how staff approached it to some degree is, what's the intent of it? Could they have done it a different way? And that became the issue for us. So if they'd come in and subdivided the tract, as opposed to having one large tract with multiple buildings, then in theory, they could have had more signs. I think staff's thought was it shouldn't necessarily have to go through and subdivide to create separate lots for each building to get the additional signage. I think the other issue with it is in terms of, again, the building facade sign, it depends on how that space is leased out within the building. They've got multiple different entities leasing different areas of space. Again, in theory, what they could do is come in and lease a little bit a foot, which is their sort of deal to do, and say, I've got a tenant up there, thus I need the building signage. Again, part of it had to do with the height, the elevation it was on, and so we kind of looked at it as to what degree do they meet the intent of the ordinance, and that's really how we approached it. I think, frankly, one of the challenges we have in terms of the exterior surfaces, in theory, they could just black out the edge around of the electronic sign and meet the requirement. That doesn't necessarily seem to be the intent of it. It has to do with this catch of the material and the distance and the edge. So that's how staff approached it. Not to say that necessarily the Board of Adjustment should agree with that, necessarily should approve it, but that was really how we approached it is, could they have done another way, adjusted things on paper, if you will, and then come forward for approval, and that was our logic.
Ask one other question about the masonry. I know, I'm going back probably a decade, there were a few buildings along 3009 that were built and wanted a variance to the masonry requirements. And they're small little signs. I'm not going to say what businesses they are, but y'all probably pass them every day. And I believe we denied a variance for that 12 years ago or something. Now, they're apples and oranges, but they wanted to put in at that time was not aesthetically appealing. These look nice, at least from the pictures, what we're looking at here. Now, is that going into staff's in your determination of whether?
No, it's not really about whether it looks nice or not. Again, staff probably, if you ask 5 staff people, we'd all have different views on it. I think one of the issue with the masonry requirement and things like that is state law has subsequently changed, and we cannot regulate materials of buildings the way we used to. So before, when we were allowed to regulate the material of the building, and we wanted the sign to match, that all made sense. State law changed. We can't effectively regulate the building material if it's allowed by building code. And so then we have this quirky now requirement with regard to the signage and the masonry or whether it matches the building. So again, not say you have to agree with it. That was staff's logic on it. Again, we hope to go through and do an update of the UDC this year. And these are some of the things I think, as Dan mentioned, we probably need to go through and address because they made sense in the past. When one set of the ordinance changes, not sure it makes as much sense anymore.
One other question. Staff's opinion about the size of the building and the multiple signs that will be on that building. And I bring that up because we've done that in the past for some very large buildings in the city. It really would have kind of been ridiculous for the one sign. H-E-B was one. I think Amazon was another one. These enormous buildings. Now, I guess my question is, does staff kind of consider that to be in the same
No, it's a little bit different here. What we did when we came forward before, and then we subsequently amended the code, as you note, was we had these really large buildings, and the signage that was allowed just frankly seemed too small. The issue here really has to do with how many tenants there are in the building, the tenant lease space that those have, and thus how many signs are allowed accordingly. And so one of the things that the ordinance says is, as you note, and these are sort of all related, or a number of them are related, is it has to do with the building signage is based in part on who the tenants are, the number of tenants, the amount of space they lease in that, and that's the issue. It's not necessarily that they wanted a whole lot more signage. It had to do with where the signage is located based on the tenant lease space. If that kind of makes sense. It's a little bit confusing, but what I would say is we have a number of different requirements that go to how much, how many, and who can have a wall sign, and they sort of interrelate to one another. And this became this issue of, well, what space are these people leasing? How much are they leasing? And it had to do more with placement because of some of those requirements than it was. Fundamentally, they just wanted a lot more signage than was allowed. And we've had that in the past, too, where people say, I want smaller signs, not necessarily more, and this kind of played with that. Thank you. So, for what it's worth.
Yes. Do we still have the overlay area with signs on FM 3009, or is it all open and everything?
We still have some, the UDC still references different sign requirements for some roads. So yeah, certain roads have different requirements than other roads with it. And I think 3009 is one of those in terms of the height being different and things like that, yeah.
Do we not also have moving of all that?
We do, so we allow electronic signs. Now, we've got some limitations, how quickly that face can change. You can't show a video, for example, per our code. You can have the image, it can change. The requirement that we've got is if you've got an electronic sign, that's your only freestanding sign you can have. And so again, to the question from Mr. McElroy, really went to if they had come in and sort of subdivided the property, in theory, then you've got multiple sets of lots that can do the electronic sign, they can do the other freestanding sign. And that was the basis there. But we do allow electronic signs. We just don't have that many people that do them.
Oh, this one will be an electronic sign.
It will be, yes, sir. And they're allowed to have an electronic sign. Again, the issue would be is, per the code, if you do an electronic sign, that can be your only sign. And then we've got that requirement of the text or graphic not being within 6 inches of the outer limits of the sign face.
Well, it seems like, whenever you're redoing your ordinance on this, it seems like we only get to see the ones like across the street from them. We see no signs. And there were 2 extras added, one for the bank and one for whoever was at the end down there wasn't getting a show off of, whatever.
Understood.
Anyhow, there's other signs that we have no input on, and it seems like it's multi-tenant places that we do. Why do we have to have 2 signs on the road? They're both basically saying the same thing, except one is flashing in the other.
So let me be clear. You don't necessarily, and so again, you don't necessarily, if you have this finding, have to approve both. Again, the question had to do with why staff recommended what we did, and again, what it has to do with is 1 sign per property. Again, they've got a fairly large tract of land. I think part of what staff factored in is if they came in and subdivided the property, created 2 lots, then they could put up their 2 signs. That creates some additional issues and seemed a lot of hoops to have to jump through to be able to get the 2nd sign.
We had one resident come in and speak on all the signs. And once you know where your place is, I mean, the first time you leave an hour early and find the place.
Again, I don't disagree with you there. It doesn't as much carry weight for staff that somehow nobody will be able to find the thing and get into it.
Well, I think that just the ordinance needs to be changed to not hold us at hostage. Well, I'll just go ahead and divide it, and each one will be separate and neat as.
Yeah, don't disagree. That may be something we want to look at going forward, because I think, again, from a staff perspective, part of it has to do with, and this was our challenge on this one, if they had come in and subdivided, they could have done 2 signs. That was the basis in the approval. I think what we try to do is sort of a uniformity of application, that essentially if we have this project or this project, we would do the same thing for everybody across the board. This is one of the things that I think we sort of struggle with, is what it's not based on is it doesn't say if you have a project and you have X number of square feet, say between, up to 20,000 square feet, you can have 1 sign. If you've got between 20 and 40,000 square feet, you can do 2 signs. It references sort of the lot, which again, to us, creates some issues. And to be blunt, there's no perfect solution. However much we may work on updating the ordinance, writing it, I can guarantee to you, at some point we'll be back and saying, here's this thing that either we didn't think about, or we hadn't thought of this scenario, or we had, and they just want something different. I think we do pretty good, ironically, with the fact that we're approving minutes from, where was it, 2020? All in all, I think we've made some adjustments to the sign ordinance to get out of what we were seeing for a while, which were a lot of requests. So.
That's it.
All right. Just real quickly, one of the things that is based on what we're discussing now, is this something that can set a precedent for an adjustment in the ordinances because of this?
So I think, as Dan will tell you, you've got to find facts specific to the case and the project going forward, and just because you do something here doesn't mean you'll have the exact same circumstance going forward. But at the same time, I think you certainly want a consistency in terms of your decision when those facts are similar.
So, yeah, and the only thing I would add is if we were consistently seeing the same types of requests for variance, yes, and I've made that recommendation in other instances where I had boards of adjustment, for example, in one city, getting variances for carports every, it was the carport board is what they started calling it. It's like, well, then perhaps we should look at why you're requiring a variance for carports.
And those of you who've been here a while may in fact remember when we were getting variances for car. I'm not sure he's referring to us, but
I remember that.
We were getting it, and then we modified the ordinance accordingly. And so I think that's consistent with the kind of comments in the question. If we find ourselves getting these, then, hey, maybe our problem's different.
All right, thank you. Any other questions? Anyone? Okay, do I hear any kind of motion on this?
Okay, let me see what I'm going to do. I don't want to approve the electronic sign. So how are we going to do this? If we disapprove it, can he come back with something else?
Say this again.
So let me make sure I understand your comment. And again, you can't go above, but let me know what, again, you're thinking, and I'll see if I can.
If we go ahead and disapprove this, can he come back? And they've sat in here and they've listened to what our concerns were. Or, well, maybe we need the attorney to tell us.
So are you looking to deny the whole thing, or is the electronic sign your area?
The electronic sign is the biggest one.
Okay.
And I don't personally feel that we need 2 signs in front of that building.
Okay. So what you could do, because I would again say this, they're kind of, I'd group them 2. So the first 3 bullets really go to wall signs, the signage on the building. And so in theory, what you could do is you could grant the first 3 to allow additional wall signs, to allow 2 wall signs on the same facade, and allow a second, or do the first 2. You could then deny the second multi-tenant sign, not approve the increased square footage on the multi-tenant sign. You could not allow the electronics within 6 inches and not modify the masonry. You could basically approve the first 2 and deny the next ones if you wanted.
These signs, wall signs, are they going to be lit up or anything, or are they just?
They'll probably be backlit. Most businesses backlight them, so they've got a light inside, so at night you can read them. That's typically how they are.
The lady over here on William Scarborough will see them flashing all night, or no, just are there shining in her door. I think that we can put up those the multi-place signs on the facade. No lights. Maybe you might need them in front though for emergency.
Oh, excuse me, in this presentation, is there a motion that you want to make in regards to it, either eliminating certain portions of it that we talked about?
Yeah, and if I might, just a point of
Please.
order, Mr. Chairman, and staff, and also to the city attorney as well. My understanding and the way we've done this before, in my experience, is that as there are separate requests within the overall, that it can be approved or denied as per that request.
That's correct.
Or it all could be disapproved or all approved, either.
Correct. Yes, sir.
But maybe we're making a mistake. Like across the street, we have the tenant sign, and then on each building, we have who we are. Is this, we do a disapproval on something, are we taking something I think you need?
I think it's outside of our purview to decide what they need. Yeah, I'll make a motion. I'm gonna handle this one by one, though. UDC section 29.11.9.c, the 3 wall signs, where the applicant is requesting the 4 wall signs. I would move to approve that as requested.
Do I hear a second?
Double check this, these first 3.
Do I hear a second? Second? Okay, we have a motion from Mr. McElroy, a second from Yvonne. Any other questions? No? Okay, can I have a vote, please?
Aye.
Aye.
Aye. 4 ayes, motion passes and carries. Thank you. All right.
We still have more.
Yeah, Mr. Chairman, I'd further make another motion.
Go ahead.
The UDC section 29.11.9.c, 1 wall sign per wall, where the applicant is requesting 2 wall signs on 1 wall. I would move to approve that as applied for.
Second.
Okay, we have a motion for, what is it, 1 wall sign? Is that basically what you're saying right now?
The code would allow 1, the
Okay.
applicant is requesting 2 on 1 wall.
Okay, and we have a motion from Mr. McElroy, a second from Mr. Herzog.
Clarification, that is 2 wall signs.
2 wall signs, right. So we have the motion. Any other questions? All right, vote.
Aye.
Aye. Okay, so that carries. So have we taken care of this? Go to the next one.
Well, the next issue, all 3 of those have to do with the multi-tenant signs, whether the monument sign or the electronic sign. If, depending on how that vote goes, then there may not be any other, so I guess,
I don't think that.
I'm sorry, Steph, I thought.
No, I would agree with you there. I think the first one is whether or not you're going to allow that second multi-tenant sign. Once you do that, you've, I think, kind of set a bit of a path. We have a few more to do, but I think that's the big one.
I think that would go as well.
You want me to do that?
Yeah.
Yeah, I'm not going to make a
Go ahead.
motion.
I'll make a motion that we not allow a second multi-tenant sign on the property.
And I would second that.
We had a motion not to allow the second multi-tenant sign. It was seconded by Mr. McElroy. Can we have a vote on that, please?
Aye.
Aye.
Nay. So we have 2 and 2, the board stands.
So I think, and Dan can correct me, what you would need effectively, what the board has to do is,
We need to be able
Well-
to take a look at this and maybe have a little clearer picture of just exactly what it is that we're looking at here.
so,
Can you, I'm sorry to have to tell you to do this.
oh, no.
And it just kind of,
So this is what the request is. It's essentially, per the code, they can get one freestanding multi-tenant sign. They are asking for 2. So what we had was a motion to deny, it failed. In theory, what the board would have to do is have a motion to approve it, and that would have to succeed. Now, if what happened as a hypothetical is, we had a motion and a second, but it split the same way this one did as 2-2, if nobody came up with a motion for some kind of reduced variance, 1.5 signs that was within the notice, then effectively, you've not approved it, we would then move on and consider that to be denied effectively. Is that accurate, Dan?
You have to have a 4-0 vote to approve anything.
That's right. So if you can't get a 4-0 vote to approve it, the effect is it's not approved and we move on.
all right, at this point, that item is not approved, and we will move on from that section. Is that?
Well, so
right,
what you
Dan?
had was a motion that failed.
Right.
Because we need a motion in the affirmative as opposed to in the denial. So you could have more discussion, you can discuss alternatives here, but at some point in time, the motion should be to approve, not to deny, even if that motion fails.
Yeah, so if you make a motion to approve, if the 2 people that just voted against make a motion and a second to approve, and then you vote on it and it's split 2-2, then you're done on that one. Okay, it's a little bit of a backwards way, but that's effectively what I think would happen is the folks who voted against it make a motion to approve it, second it, vote on that and see where that gets us.
Okay. Let's try that one again. Can you just restate, and we can kind of maybe go over that?
So typically, if I may, if this helps,
We have not.
I'm sorry, if one of the people who voted against would make a motion to approve. Okay,
I'll second that.
okay. And then now you would call for a vote.
Vote?
No.
Mr. Jevitz?
Aye.
Okay.
It
So,
has failed.
so now what we had is we had a motion to approve that failed, 2-2. At that point, the items are not approved.
All 3 of them, she made the motion for all 3.
She made the motion for all 3, so effectively, you were done, I believe, on that item. Was that all the items?
She made a motion on, to allow, let me just make sure I'm correct. So you want to make a motion to allow a second multi-tenant sign, to increase the square footage on the multi-tenant sign, to allow the text and graphics, including electronics, to be within the 6 inches of the outer limits on the sign face.
All of those? Okay, so.
All of those.
Yeah, so if your motion was to approve all 3 of those, then that's failed. We move on. There was technically one more, there was the 4th, and that's to allow the reduced masonry requirement.
Okay.
So again, we would just need a motion on that, see where it goes, and then,
Let me just,
You know,
let's just put a hold on, just for a moment here. Let's make sure that everybody here understands just exactly where we are. The first items to allow the additional wall signs was approved.
those were approved. Yes, sir.
The second one, to allow 2 wall signs on the same facade, was approved.
Yes, sir.
The one to allow a second multi-tenant sign was the one that was not approved. Okay? So now we're down to the 3 items that are on the bottom here, which is to allow increased square footage on multi-tenant sign, to allow text and graphics, including electronics, to be within 6 inches of the outer limits of the sign face, and to allow reduced masonry requirements for multi-tenant signs. Those are the three that we're talking about. And at this point, I think if I, those three items are the ones you want to approve?
Can I withdraw that one and go back and do them one by one?
No, we've already done the first.
okay.
Let's,
We've done all of them.
we've done three, 1, 2, and 3. What we're doing now is the last three items on here. These three.
So
Okay,
I think, Mr. Jevitz, if this helps, and let me, Ms. Griffin, to clarify, was your intent to recommend approval to allow the second multi-tenant sign, to allow the increased square footage of the sign, and to allow the text and graphics, including electronics, within 6 inches?
It wasn't, but I was going off of his same.
I got you. Okay. So then if you could clarify what your motion, what the intent of your motion was?
Mine was to allow a second multi-tenant sign.
okay.
Okay. Sorry. Okay, go ahead.
Okay, my motion is to approve the second multi-tenant sign.
Okay, just that. Okay.
That.
So was there clarification on everyone that that was the motion?
Okay. That's the one we had the no vote, I believe you said?
I don't have an issue with having that be the motion that's before the board here. Although I want to ensure that that is proper, taking a vote.
Sure. So let me ask the city attorney, in light of the confusion, what would you suggest?
That's what I'm looking at, okay. All right, I make a motion to approve UDC Section 21.11.12D, second multi-tenant sign on the property.
Okay.
Okay, all right. Based on the items that we have listed on the whole group here with the, if you can go back to that one where the 5 items were listed, please. Yeah. Okay. Let's see if we can kind of work this out in this fashion over here. 1, we're looking at items that we approved, which was the first 2 parts of this recommendation. Is that correct?
Yes.
Okay. So now we're going to item number 3 on here, which is to allow a second multiple sign. All right? Now, is that what your motion is about, that particular one?
Yes, to approve
Okay,
it.
and to accept it?
Yes.
Okay, so I have a motion for item number 3 to accept. Do I have a second?
I'll give you a second.
All right, we got a second from Mr. Herzog. Let's vote. Start with you, Yvonne. Yes?
No.
No. Else.
I said yes. So, all right,
Okay.
so we got a 2 and 2.
2 and 2.
Same situation that we had pretty much before.
So the motion fails.
Right.
So so that's not been approved. We can now move on to the next one.
All right, that's what I'm looking at.
Yep.
All right, let's move on to item number, the next one, which says to allow an increased square footage on multi-tenant sign. And we had a motion on that, I believe.
No, not
I don't think there was a motion, was there?
We don't have the second
Sorry?
sign anymore, so
So this would apply to the only one sign at this.
That's correct. So to allow increased square footage on that,
So then we could specify that that's for one sign, correct?
Mr. Chairman, I'll make a motion to approve UDC Section 21.11.12.c and G, the remaining 3 items as it applies to the sign that will survive. Multi-tenant sign to be 194.94 square feet. Text, graphic, and electronic elements to encroach within 6 inches of the outer limits of the sign. And based on the information of the city essentially not being able to enforce the building material, the base of the constructed of the rock, rest of the sign to be aluminum with a stucco finish.
We have a motion from Mr. McElroy for the 3 items. Do I have a second?
I'll second.
Second from Yvonne. All right, we have a motion and a second, and let's call for a vote.
Aye.
What are we specifically doing, please?
you're approving these other 3.
Just the 3.
As it applies to the surviving sign.
Yeah.
Okay. Your vote, Mr. McElroy?
It was aye.
Mr. Herzog?
We're going to still have the multi-lights on here?
They can do one electronic sign, yes, sir. Per the code, they can do an electronic sign, and so they are requesting just the one electronic.
Yvonne? Aye.
Okay,
Passes.
all right. Thank y'all. Sorry for the confusion. These are tricky. We appreciate your patience.
All right. Moving on to the next item, which is BOA 2021-002. That's hold a hearing, consider and act upon a request for a variance to Unified Development Code, Article 5, Section 2.1.57, Dimensional and Development Standards, Single-Family Residential, District 6R6, in order to reduce the front and setback from 25 feet to 20 feet, reduce the side yard setback from 10 feet to 5 feet, and reduce the rear yard setback from 20 feet to 0 feet, located at 3709 Hillside, City of Schertz, Guadalupe County, Texas. Okay, what we'll do is we'll have the presentation by staff, please.
Okay, sorry, my apologies. So this is for BOA 2021-002, more known as 3709 Hillside, Scenic Hill Subdivision, Lot 34. So here is the public hearing notice map. We had 35 notices sent out on January 14th. We did receive 2 in favor, 3 opposed, 1 neutral, 1 that did not decide, and then I did receive 2 more after the staff report. So I know that was kind of a lot, but that was what we received on this one. So just for reference, this is Country Club Boulevard, and then this is Hillside, and this is Lot 34. So this one, I'll go between this slide and then the next slide. So the applicant is requesting to have a 20-foot front yard setback, a 5-foot side yard setback, and a 0-foot rear yard setback. So the zoning district that is currently, allotted for this lot as well as other lots in the Scenic Hill subdivision is the R6 zoning district, that single-family residential zoning district. That being that under that zoning district, the front yard setback is 25, the side yard setback is 10, and the rear yard setback is 20. However, so I'll go to the next slide just to provide some reference. I apologize, it's not as big, but there was a vacate and replat that was done in 1987 for the Scenic Hill subdivision. When this replat was done, the front yard setback was designated to 20, the side yard setback was designated to 5. However, the rear yard setback was not provided a lot or a dimensional setback. But I do want to note that this property is abutting a 20-foot greenbelt and utility easement. So that is what the applicant is requesting, is to have that 20-foot front, the 5-foot side, and the 0 rear. Here is the variance review criteria that was provided within the staff report. So this one is one of the last 2 vacant lots that is currently in the Scenic Hills subdivision community phase 1. So with that being said, there have been other lots that have been built. They've had homes there for 25, 30 years. And so with that being said, or Brian, do you want to?
Can you want to pull up an aerial?
Yes.
Can you, Megan?
Yes.
So I think one thing that's interesting about this one has to do with the, and you can take off this.
Okay.
Has to do with the timing of this, when this subdivision was developed, when it was annexed to the city, when most of the lots were built, and when then the city came in and imposed zoning on it. And so as Megan has indicated, one of the issues that we've got in this subdivision, as you can see a couple houses down, and with the houses here, are that most of them were built prior to the zoning being in place. And so again, the lots that we have out here generally do not comply with the zoning because of the timing of the development of the subdivision, the annexation of the property, and then the city coming in and imposing zoning. And so again, what we essentially have is this very unique situation with 2 lots that still haven't developed, and that thus now that they're coming in, the city having to zone it has created some challenges, and thus the applicant's requesting a variance. So again, it's a fairly unique one from staff perspective, is that timing of the development and the lot sizes that were created at the time when it was assumed that the property would not have to comply with these setbacks and the zoning regulations. If that's helpful, why there's a bit of an unusual history on this one. And I'll get back to the PowerPoint. And the applicant is certainly here to speak to that history and when they bought the lot and how it developed as part of that. Sure.
Leave it up to the chairman. Would you prefer to hear from the applicant before we ask questions, or?
Well, let the applicant speak first.
Okay.
Which slide would you like for me to go to first?
Let's go to the one plat that shows the 20 in the front.
Yes, sir.
The, the larger plat.
Yes, sir.
That one. Good evening. I'm Charles Luther. I'd like to introduce my wife. This is my wife, Barbara. We've only been married 55 years. It'll be 56 years in August. And so happy to have her here as my co-sponsor here for what we're trying to do. If you allow me just a few minutes to sort of give a little bit more of an introduction and information about myself. As you can tell by looking at me, I've been around a while. And I have a background in the military. I served both active and reserve in the military, retired as a brigadier general. As far as knowing a little bit more about myself, I really believe in community service. And during the time that I was off active duty and in the reserves, I served on the Universal City Planning and Zoning Commission for over 5 years, and that was a number of years ago. I've served on many homeowners associations, and I'm currently not on any HOA. I was just recently, my term expired where I currently live, which is a homeowners association, and I've served prior to that as the president of the Architectural Control Committee of that subdivision. So I'm familiar with all the issues related to subdivisions and setbacks and covenants, conditions, and restrictions, all those kind of things. In terms of community service, I am an endowed member of the Schertz Masonic Lodge here, the Randolph 1268, and was a prior leader of that lodge, or what they call the master of that lodge. Still an active member of that lodge right here on Main Street. And I'm also an active member of the Shriners, and we're heavily involved, as you all know, the Shriners, in helping handicapped children, burn children, and those hospitals related there too. Moving on quickly, I have quite a bit of real estate experience also, and been an active real estate broker since really in early 70s. I'm also a member of the National Association of Realtors, the Texas Association of Realtors, and the San Antonio Board. And the reason I mention that is that we have each of those boards has very strong codes of ethics, and I fully subscribe to all those. And over all my career involved in real estate, I've never had any issues related to that, and I really believe in doing things right. And I've also, in my history, I've developed subdivision, starting from scratch, where we would do all the plats and everything. And I've done both rural subdivision, where you put in streets and have acre-sized lots. And I've also did a City of San Antonio, Unit 11 of Thousand Oaks, which is about 300 houses in that unit. So we were the developer of that particular unit. So I've also built the last 4 homes that my wife and I personally lived in, and prior to that, I've built literally hundreds of homes, both tract houses and custom homes. The reason I give you that background is that I don't claim to know everything about real estate. I learn something every day. But I just wanted you to have a feel for the fact that I've been in and around this community, Universal City, Schertz, surrounding area for many years, and I plan to move back to this area at Scenic Hills. So being a sort of a planner, and as we're now wanting to downsize into a smaller place, several years ago, in fact, way back in 2008, we bought this lot, 34, out at Scenic Hills. And we were really attracted to Scenic Hills for many reasons. One was it was a fully built-out subdivision. In other words, it had been built out and been properly kept and maintained, and was an excellent community, and it had been that way for 25 or 30 years. So we were fortunate to find a lot there that had not been built on, and we bought that lot. And this plat you see in front of you there is what was available to me, and that's what I looked at the time that I bought the lot, with the intention of building with those setbacks as specified there. The 20 feet in the front, 5 on each side, and no setback requirement in the back, because it already abuts to a 20-foot green belt and utility easement. And it is a real gated community, so the wife and I, as we downsize and go into our retirement mode, we feel like that would best fit our needs. And we really liked it because one of the things that they have is you pay your homeowner association and they mow the yard for you. In other words, all the yards out there are mowed by the HOA, as well as all the sprinkler systems and everything, all properly maintained. So it's a very well-kept subdivision. And there's a lot of good, friendly folks out there. And so we're very much looking forward for the opportunity to build out there. Now you might ask, why are we asking for a variance request now? And the reason is, as part of doing my due diligence in preparation for planning a home to go on this site, I found something very unexpected. I found that it had been zoned R6, and when you apply the general rules for R6 zoning, the setbacks were specified. The front went from 20 to 25, the sides went 10 feet on each side, and then there was a 20-foot requirement in the back. And I really need to know what the allowable building footprint is before I commit to the expense of having a new set of plans and specs and the whole package, which is quite expensive to get ready to build. And I certainly intend that when I get that site plan and all the plan and specifications related to the construction, that will be formally submitted to the Scenic Hills Community Association for their approval, and then it would obviously come here to the city of Schertz for approval. So there's going to be an opportunity for everything about the structures I'm going to build on there to be reviewed as part of that very detailed package. But if I have to live with these setback requirements under R6, it's going to be very difficult to, in fact, for me, it would be sort of economically infeasible to try to build the house I want on that small lot. In fact, if you look at the width of the lot, 65 feet total, and you take off 20, that leaves 45 feet. And what I'm concerned about, and part of my justification for asking for the variance, in addition to the needs that I have to build a house I want there, is that if you build a small, narrow home like that, it's not going to be a tiny house, even though those have gotten popular lately, but it is going to be an anomaly. It's going to be very noticeable as you go down the street. It's not going to fit in to the neighborhood, in my opinion, and it's going to be different than all the other homes that have been built and are mostly built out for 25 to 30 years. So all the people who have previously built there have been able to build right up to the 5-foot setbacks, and in some cases, some of the lots out there has 0 lot lines on one side. And so, so I just want to state that I believe that if my request for these variances for these setbacks are not approved, then I will not be treated the same as all the people who've already built out there. And secondly, I believe it would create, if I were to build a narrow home there, complying with those setbacks, and be a pretty small house, that it really would not be in keeping with the rest of the neighborhood. And the application of these more stringent setbacks on this very small lot, because this whole subdivision was designed from the onset to be a retirement community with small lots and a very little yard for people to worry about. And it was, a retirement community, a real gated community for people 55 and older that are sort of in retirement mode. So in looking at some of the responses that came back from the neighbors, one of the major issues, oh, by the way, before I mention that, as part of my due diligence and as part of preparing for this presentation here tonight, I was able to get an affidavit from the president of the Homeowners Association, Mr. Danner, and he's in favor of the approval of the setbacks that I've asked for, and a variance to R6. Additionally, Mr. Norman Shahan, who is the chairman of the ACC, has an affidavit, and that's in your package there, I'm sure you saw it, that they also approve it. But then, as I started to say, one of the issues that seems to be of concern to several of my neighbors is the whole issue of water runoff and drainage. And so what I want to assure you all and anyone here, all of my neighbors, is that when I do a site plan like is required, that detailed site plan, which shows the siting of the construction on that lot, it's going to show the accommodation for drainage swales, all the, routing the water around not only my property, but also it would accommodate my neighbors in that the drainage swales would slope from their house toward the bottom of the swale, and then from my new construction toward the bottom of the swale, and it would accommodate the drainage between the homes, totally unrestricted, and be done in a very nice way so that it's easily mowed and those kind of things. And that's exactly in keeping with what's happened with all the other homes that have been built out there over the last 25 or 30 years. And so the issue related to the setback easement in the back, I'm asking for no setback, even though I probably will never, in fact, even on the sides, homes I've ever built, I never built exactly right on the line, because I'm out there measuring, you're 2 inches over, you've got a major problem once the slab is already formed up and ready to pour. And so, so I'll probably set back a little bit from the back, but it's already an existing green belt and utility. And by the way, there's at least 3 homes that where they have built their homes previously right up to very close proximity.
Okay. I'm sorry, I'm going to have to cut you a little short here. I apologize for that. But we do have to open this up a little bit for the public hearing portion of it. So want to thank you for what you have presented. And if you don't mind, at this point, we will close this section and open up for public hearing.
Appreciate that, sir. And I just want to add before I sit down that I'm very aware of the core values the city of Schertz has. And I support those core values, and I intend to do the right thing, and respectfully request you approve my request for variance. Thank you.
All right, thank you. All right, at this point, for this particular item, we will open up for public hearing. And anybody that has anything to say in regards to this, and I believe, is it Ms. Crenshaw?
Good evening. My name's Pia Caruso. I live at 3705 Hillside, which is right next door to this lot. I'm sure that your city planner has done a lot of research on this, but I never did hear if she approved this request or not. They never said that. They just said that they talked about other things in the area, but they never said that. So could I find out, are you recommending approval for this or
Yes,
not?
Staff is recommending approval of the variance.
Okay. Thank you, Mr. General, for your comments. But I'm hoping that you will give me the same courtesy of the time allowed to speak. I myself also was in the military. My husband was also in the military. We also believe in public service. And if I went into a lot of the things that I'm doing right now to help my neighborhood, then it probably would go more than my 3 minutes allotted. But there are several things that I would like to say in rebuttal to what the general has said. One, I don't think that there are a lot of houses built in our section that are abutting the property line. There may be a few, but not a lot. I don't know if you've considered the slope of the property. When we moved into our house, we thought there was no problem with it, and it is set back from the back of the property as it should be. And we have had a real problem because there is a 25% or so slope to the property from the backyard. and we had a lot of problem with water incursion into our home, into the foundation of our home when it rained very hard. We had to build a water abatement drainage area in the back of our house. Mary, who lives next door to me, had to do the same thing. If I had had no setback on my property at that time, there would have been nowhere for me to put that extra drainage. And I see the same problem would happen with them because the property line, the property slope is so heavy that that water is going to flow down. When it hits his foundation and comes around, I don't know what that's going to do to my property. Okay, that's one of my complaints about it. Second of all, they're talking about moving 5 feet closer to my bedroom windows, and that doesn't make me real happy, because I like to keep my blinds up so my cat can sit in that window. I don't see anything from the presentation that was given about given these variances. I didn't see anything in there that would cause you to want to approve this variance. They said, you know, the lot doesn't fit in the ordinance rules for doing this variance. There is no hardship. And the other thing that I want to say is I have been told, and it is probably hearsay, that the reason that they would like to get these variances is because they want to build the exact same house, the same square footage, is the house that they just built, that they're living in now. And it doesn't fit the lot. It's too big. You know, it doesn't make sense to approve this. The house is going to be so much bigger than the other houses around it. I don't see any problem with giving them the variance for toward the road, but when you're talking about incursioning into our area and having no setback in the backyard to allow him to build the proper drainage so that the water will not go into our area and won't also be affecting his own home. You know, we had a bamboo floor. The water was hitting our foundation, and the floor started bowing. Anyway, so those are my objections. It just seems like the home is too large for the lot, and if it's too large for the lot, then they should build it either a smaller home or get a lot that fits the size of the house. Thank you.
Thank you. Is there anybody else? Okay. At this point, we will close the public session for this one and ask the board any questions. Could we have the staff, please? Thank you.
Mr. Chairman, Mayor. Just a question to city staff. And some of this is already, as it's been submitted, part of the record. So a lot was purchased in February of 2008.
Yep,
Replat was done in 1987.
that's right.
And looking through the rules, the only thing that I can ascertain is that the reason this is even before us is because the replat is silent as to the rear setback, which then throws it back to the current way that area is zoned. Correct?
Not necessarily. I mean, I think you have this issue in terms of, and again, I think the challenge is this property was platted prior to being annexed into the city of Schertz. And so it was platted without zoning. The setbacks on the plat were what applied. Houses were built prior to it coming into the city. And so you have what you have out there. With the subsequent annexation and then imposition of the zoning would technically prevail. But the issue I think that staff has is when we look at a hardship, it's again, the property was platted, the lot size was created, all the other houses were built and set back without those regulations in keeping with it, and that's staff's recommendation for approval.
On the item summary, it states that it's allowable, the requested setback is allowed per the recorded replat.
That's right.
What you're saying now, though, is that after it was annexed, that wasn't necessarily be the case.
Yeah, that's the issue that we have here, is the property was annexed after the fact, and the zoning was then imposed on it after that.
When was that? When, do you know when this?
I can look it up for you. Let me pull it.
Yeah, I can I? What is the square footage plan of the house? You
Sir, I don't know yet. It was, it would be somewhere around 2,000 square feet. And certainly, I don't know where the rumor came from relative to wanting to build the exact same house. The house I'm currently living in would not fit on this lot, nor would I attempt to build that
But
on this lot.
what size is this footprint that you put on this here lot right here?
Sir?
What size, what is the square footage of the building surface that you have?
I guess I really don't understand. The total square footage of the air-conditioned area would be somewhere 2,000, 2,200 square feet. And you're going to have porches, and you're going to have, unair-conditioned area and so on. But the problem is that I want to build with, 5 foot back from the sides, 20 foot from the front, and really I would like to have 0 in the back, but I could have a little bit in the back.
As a point of clarification, I think what we're looking at here is the full amount that fits within the requested setback. Not that the house would even take up that full amount, but
No, it won't, no.
that rectangle within the rectangle would be a full amount within the requested setback.
Right. I don't intend to take up the whole within the dotted line, so to speak.
Okay. So the property, the vacate and replat was done in 1987. Annexation was approved in 2001. So I apologize for not having that.
1987.
I graduated high school.
I'm thinking of where I was.
I don't think Megan was born yet, probably. That's the upsetting part. Some people feel bad when I said I graduated high school. She wasn't even born yet.
But I thought in 87 that this never made it. It didn't get passed. Is it the one that's on file over there now?
Yes, sir. Yeah. So again, I think that's the issue that we've got on this one. It's a bit of a convoluted, and again, as we noted, the rear yard setback wasn't listed, which kicked this over in definitively needing a variance for that, but running all those as well.
Okay, and I just asked that question just to determine what the relevant rule was at the time of the purchase of the property. Not that that might influence my decision one way or the other, but it's important to know. Looking at one of these overview that you had, one of these photos, drone photos that you had of the neighborhood, there was very clearly there was a home about, there are two homes away that is absolutely on that setback, on that rear setback. There may be others if I look at that a little closer.
Yeah.
I just need some clarification about the city's position on the allowable further recorded plat, which is the 5 and the 20, and what the current is, which is the 10 and the 25.
Sure, and so and it's which one holds effectively, since we have this.
You'd explained before that it's the way the code is currently. However, then if allowable per the recorded plat, irrespective of what the code says now, or the ordinance says now, then what are we here for? Is it just that back setback?
And let me read what the code says. So essentially, no portion of any building or residential lot may be located on any lot closer to any lot line or to the street right-of-way line than it authorized in Table 2157A unless otherwise listed below. 2157A is the setback requirement under the zoning. And essentially it is where the building setback line has been established by plat and exceeds the requirements of this UDC, the more restrictive setback line shall apply. So the issue is that the more restrictive is what applies. That's the current city zoning.
So, then why does it say allowable per the recorded plat? That's irrelevant.
And that, I think, was, so you understand the basis of why staff is recommending approval is because we have the plat that has one thing listed and the zoning has come in after the fact.
Any other questions?
Yes, I have some comments. I don't know if it'll wind up being a question or not. I went up to see, this place. I was in that subdivision. I went over to the lot. Very nice neighborhood up there. Wide lots, 10-foot side lots. I don't know about the 20-foot. I didn't look in the back at anybody or anything. But it's a very nice area. And every one of the comments, or almost all the comments we had from the people, was the drainage. There was a problem with the drainage. And I can see where their property over there was flooded. I mean, I could see that. The water was hitting for their house. If you put a 5-foot side and cut off at 20, I don't know where it would go.
So I will say this, Mr. Herzog, that the applicant will have to comply with the city's drainage regulations. Those apply today. So again, we do not allow lot-to-lot drainage. He will have to bring the drainage to the front of the property.
What I seen on the size on that plat that was there, it doesn't look like it's going to be 50% impervious on the properties. I don't know what to say. I think that the square footage you're proposing will probably leave a lot of room open. I don't know. Ready for a motion.
Yvonne?
I do have a question. Back when this was annexed, how much of the subdivision was done? Was it completely built out?
I think most of it was built, is my understanding. I don't have that exactly, but I think that most of it was built, which is why we've not had this problem, because most of the houses were built under those old regulations.
Okay, because it looks like by this overview that a lot of them are on the lot lines.
That was part of staff's recommendation. When we went out and took a look at it and what we had out there, it appeared to us that pretty much the entire subdivision, can't say everyone, was developed under those old regulations, and we've essentially got a couple of lots that are left to go. Again, to us, that seemed to create a hardship that effectively what the others were able to build to should apply here.
And they are required to get engineering approval?
They are. They have to go through our permitting process, and they have to comply with our stormwater ordinance. And so, again, they would have to accommodate that. And again, again, they cannot drain onto their neighbor's property. They've got to bring it down to the front, into the street.
There are no more questions. Do I hear a motion?
Mr. Chairman, I'll make a motion to approve BOA 2021-002 as submitted.
Do I hear a second? Have a second from Yvonne. Okay, any other question?
Yes. Could we change that? Put something in about the
No, you can't really impose that condition. And again, our regulations on drainage would apply, and so that's one thing we look, when they submit, they have to provide a drainage plan showing how that drainage is going to be conveyed to the front.
Can we put that in that motion?
You can't, there's not a reason to, you can't impose that condition. I'm just simply saying that that's what our regulations comply. But you cannot impose a condition as part of the variance.
Okay. If we approve this,
Well, point of order, I think we need to go to a vote at this point if we have.
Right.
We have a,
no discussion?
okay.
Aye.
Start on my left. Aye. Mr. Herzl?
I just don't think, I think we need to have something on it about the drainage, and it's not being held liable. Not us, but the city winding up in.
Maybe the city attorney can speak to the liability issues with
On.
the city.
Aye, 3 ayes, motion carried.
You need 4.
You have to have 4. You have to have 4 or 5 approved.
We have to have 4?
Can you speak to that issue of liability, Dan, to the city?
So they're going to have to, the site's going to have to develop in accordance with our standards. And so it won't, I mean, the site plan or the permits won't be issued. It's not going to be approved if it does not comply with our drainage standards.
We could put in there as not to hold the city liable from your actions, or something like that.
Yeah, so the city is not going to be liable because of the granting of the variance at the variance.
We've done this before. The city has been liable for drainage problems. Up in Savannah Square, one of them put that drainage pipe in.
All right. All right, at this point then,
At this point, then the motion has failed.
would have to be reviewed at some other time. Again, at this point, it does not pass. Okay? All right. Next item, item C, BOA 2022-01, hold a public hearing, consider and act upon a request for a variance to Unified Development Code, Article 5, Section 2, 15.7, Dimensions and Development Standards, General Business District, in order to reduce the front setback from 50 feet to 12 feet, and a Unified Development Code, Article 14, Section 1143, to eliminate the 20-foot landscape buffer. A requirement adjacent to public right-of-way located at 1681 IH 35 in the city of Schertz.
Thank you. So as you noted, the property is located at 16842 IH 35 North. Generally, as you can see, the frontage road of IH 35. This is Schertz Parkway right here. Schertz Bank is right here, and this is the property in question. The applicant's requested variance is to eliminate or to allow a 12-foot front yard setback and to eliminate the 20-foot landscape buffer along the frontage of their property. Again, the UDC requires a 50-foot building setback and a 20-foot landscape buffer along the right-of-way. So the two, again, of those work hand in hand, if you will. You've got the setback, you've got the landscape buffer. If you reduce the setback to 12 feet, but you still required the landscape buffer, then effectively they've still got to have the 20-foot buffer. They can't push the building all the way up to 12 feet. Again, the issue on this one is that we have an existing structure that is in the location presently. As we understand the history of it, in the past there was, TxDOT came through and took additional land for right-of-way for IH 35 across the frontage, creating this situation. So while you would say, well, that's a non-conforming use, why is the applicant here before us? The applicant wants to make modifications to that building, and the issue effectively is that you can't make modifications to that building and not lose the non-conforming status. So he's either stuck with exactly what he has, which doesn't work for him. It's become a bit of an all-or-nothing circumstance. So again, what the applicant is requesting is to get the variance, to have that reduced front yard setback and landscape buffer so that he can come in and make modifications to the building per the code, essentially. And so staff recommends approval of the proposed variance request. That's it in a nutshell. And the applicant is here as well.
The applicant's not here?
He is here.
Oh, please. I'm sorry.
Good evening, Board. Darrell John, 2813 Cedar Lane. This is my property. It has been in my family for, I guess I'm the fourth generation now, and I've operated my welding shop out of there. Grew up there, lived in Schertz for 45 years. Some of my family still lives there, but as you know, the city's growing and moving forward, and we were approached to do some development there. I am the developer. We intend to put a restaurant there. The remaining structures on the property will be removed and planned for something, maybe some office space, something more appropriate for the location, basically. However, the highway department did come through years ago and took the 50-foot away from us that was there. Now we're faced with that challenge of remodeling the building, and the building is 100 foot long. I barely have 12 feet there, and I would have to effectively cut the building in half and try to rebuild it on the backside. One of the problems there is there are some old oak trees back there, and nobody likes to tear down oak trees. So there's just enough room to actually build a kitchen back there and then a drive-through. The 12-foot is actually going to be a little more. That's what we're looking for today. But at the end of the day, there will have to be a driveway in front of it. So it's going to end up being probably closer to 30 feet, in essence, at the end of the day. But this is where we are for now.
Thank you.
Sure.
All right. At this time, we'll open it up again for a public hearing. If there's anybody that would like to speak on this particular issue, it is open. Do I have any takers? No? All right, public hearing is closed. And gentlemen, is there, ladies, if there's anything, any kind of questions that you have?
Well, Mr. Chairman, maybe not a question, but a statement for the board's consideration. Years ago, we also ran into an issue like this with billboards. The city had changed their billboard ordinance. And there was a developer, a businessman who had purchased one of the billboards over there on 78 and made changes to it. And it fell out of the grandfathering of the old style and structure of the billboards. And we spent a night even later than this that one night. Essentially that's what we're kind of considering here. An older structure, and I believe it said, what, 1975 that was built. Now, certainly, considerations I think need to be considered that that frontage road wasn't as wide as it was, I'm sure, in 1975, and the highway itself wasn't, and there's probably a lot more land there at one point. Just some thoughts for the board to think about. That's I don't have any questions at this very moment.
Anybody else?
On the applicant's request, he says the property was subject to that it was agreed upon by the city and the state to allow the buildings to remain in their current location. Do we have that in writing someplace or something that says this? I mean, you put it down, Mr. John.
What was the question?
The first one, the property was subject to, I say, eminent domain.
Right.
Agreed upon by city and staff to allow building to remain in current location.
Yes, sir.
You have, what do we have on that?
The building is still there. And we've been allowed to operate since then. The building is still there, and we've been operating since then.
I mean, you put this down, I mean, do we have, I mean, is that in writing? Do anything?
The agreement with TxDOT?
You put it down, it's your application.
Right. It was agreed to at the time between TxDOT, the utility company CPS, because of the easement, and the city of Schertz, that we would be allowed to remain and operate in the building because they didn't want to pay to move the building at that time through that eminent domain process. And we've been there ever since.
Okay.
Mr. John, you intend to use that same building for the different purposes?
Yeah, we're going to convert it to a restaurant. It is a pre-engineered metal building, and it will conform to all the current codes, of course.
And what is it currently being used for?
It's a welding shop, fabrication.
Question for the city.
Yes, sir.
City is recommending approval. You would agree with me that that is a considerable amount of difference between the 50 feet and the 12 feet.
Oh, yes, sir. So if I may, if this is helpful, and not to jump in too soon, but again, to be clear, staff's position is the building is non-conforming, that the building can continue to exist. The issue is, as the applicant indicated, is they would like to add on to the back of that building. The problem is you cannot expand a non-conforming structure. So again, that's the issue that they've got. He could not expand the back of it, come in, open it up as a restaurant, do everything he's got, he's perfectly fine. Problem is, if he wants to add on to it, he can't do that because of that condition. He loses his it's not allowed, and thus he's coming in to get the variance to be able to expand out the back. But yeah, staff doesn't have a safety concern with the distance of the building to the property line.
Have we got a I want yet from the state on the interstate widening? Is there anything of what needs to be obtained?
So let me be clear. So the state, as we understand it, has come through and acquired additional right-of-way in some sections for the expansion of IH-35. But again, this would be staff's position. If additional right-of-way is needed, then just like the city, when we acquire additional right-of-way or easements, they can pay market value for that as it exists. We wouldn't necessarily not approve this request because somebody would have to pay for it in the future. So again, so theory, it was paid for with the initial acquisition going forward. But yeah, that's essentially why we're here, is because they want to expand the back, and they can't do that because of that non-conforming status, so they're seeking the variances to be able to expand out the back.
Mr. Chairman, I'm going to make a motion and to make a statement prior to making this motion. These types of things, these types of applications where essentially the sand has kind of changed around what initially had been there. You know, roads shrinking, things being built up, the rules changing, and similar to the prior application, the sands of time really have kind of shifted around these properties. And I'm going to again make motion to approve Board of Adjustment 2022-001.
Do I hear a second? Second from Yvonne. Okay, have a vote, please.
Aye.
I'm gonna have to say nay.
Aye.
So the motion fails, the application,
Mentioning.
it's not approved. Yes, sir.
Somebody else can come in tomorrow and put up a store and take the whole thing down.
All right.
That was the last item on the agenda. And that was the last item we have on the agenda.
All right, at this point, I'm going to just go down the board of announcements by members, city and community events attended. Frank?
Nothing for myself.
Earl?
I just have a question. Nothing on those, but where's David? I mean, is he,
He's going,
I mean, sick or?
no, he's out.
He just, okay.
Yeah. Okay. Yvonne? Yeah, the only thing I have to add is that I attended that wholeness fair that they had over
Oh, yeah.
there, which I think was fantastic, considering everything going on outside, so that's pretty much it. And the city staff have any announcements?
Nothing from us. We appreciate you coming
No.
back together.
Okay, it's
Y'all, hopefully sooner than a year and a half.
We'll see.
8:12, meeting is adjourned. Thank you all very much.